I just wanted to give a quick, I suppose, market update from my perspective before we kick over to John and Nick. And without focusing too much on the past and the COVID experience that we've all been through, we have obviously just concluded JobKeeper and ceasing some of the other temporary measures that the government introduced to stave off this wave of insolvency and economic condition that was forecast when in March last year COVID hit. And there was some really understandable concern at that time that it was going to result in some Australian businesses really struggling to get through that time. Thankfully, that's been to a large extent staved off, and corporate insolvencies for a range of different reasons were actually at their lowest level for a number of years over the past 12 months. So looking forward from that sort of economic and market perspective, some of the hardest hit industries, tourism, retail, construction to an extent, have really been helped by the federal government. They've been given packages to get them through this period. The interesting part from an economic perspective over the next 12 months will be how much can that sustain? Because realistically, we don't know what the effect of COVID will be over the next 12 months. The rest of the world is still suffering quite heavily, even though Australia's relatively unscathed, touch wood, over the last little while. So it will be interesting to see whether those businesses can use this period to maintain some business practices that enable them to survive. There's some ongoing introduction of small business restructuring initiatives by the government that started in early January. So at the smaller end of the market, you've got $1 million or less in liabilities. If your ATO lodgements are up to date and you've paid all your employees, you do have the option of restructuring and liquidation processes that are less expensive than they might have otherwise been. There's a fair bit of debate in the insolvency industry about how effective those mechanisms are. But I think at the moment that the main criticism is that they haven't been taken up perhaps as much as they might otherwise have been. Cash is king, I think, is probably my next point, that this is true for businesses throughout history, but even more so at the moment when there is uncertainty. The test for insolvency from my perspective is always cash flow test, not a balance sheet test. That's the way it works here in Australia. And it just means that every business needs to have more of a focus on both immediate cash demands and cash flow forecasting over the next 6 to 12 months while there is still uncertainty in the market. And I suppose from some of the external pressures that we're observing from my industry is the ATO, obviously. Everyone has to interact with the ATO. They've taken a pretty softly approach as well as running the JobKeeper program for much of the last 12 months. They're saying externally they're shifting to an enforcement mode, but at least from my perspective, I haven't seen that in, they're still accepting of payment plans over a significant period of time, and they're really not enforcing in any serious way, other than against the most recalcitrant debtors and perhaps some JobKeeper fraudsters, as we've heard in the news. The other one that most businesses have to deal with is their financier or bank. Again, they've been pretty softly over the past probably 24 months, partially due to the Royal Commission. And again, we're not seeing a whole lot of movement on that front at the moment. We've got a few matters at the moment where the bank is clearly significantly in the hole. The director's company has gone under. The director himself has personally guaranteed and saying, you need to grab this property because even if it sells now, you're going to be $500,000 under the water. And the bank's just sitting back and saying, I'm not going to jump in there and do anything. And this is a significant commercial property worth upwards of $6 million in billion. So it's just interesting to see that the banks aren't taking that step at the moment. And I suppose partially that's the bank's attitude is helped by the fact that a lot of businesses have been careful with their cash. They have received JobKeeper and some cash stimulus over the past 12 months. So the sense we get from the general market is that a lot of those businesses have actually more cash available now than they did at the start of COVID. One of my clients was telling me the other day about a business that actually took their secured debt down from 15 million to 5 million and went from bad bank to good bank, despite the fact that they were barely trading throughout the COVID period. That's probably an extreme example, but there are others like that in the market. Another impact that we'll have to consider over the next 12 months is obviously China's trade attitude with Australia. We've seen in recent months the impact it's had on industries as diverse as wine, lobsters, and others, coal being another example. So it'll be really interesting to see how that relationship from a trade perspective develops over the next 12 months. From just a pure creditor point of view, I did want to raise, we've said ATO and banks are going softly. The one positive for trade credits in the market is that you are able to be a little bit more proactive now. There were a whole series of measures through COVID that said, for example, statutory demands were a 6-month time limit. They're now back to their traditional 21-day time limit for compliance. The budget has just recently come down and they are increasing the minimum amount from 2,000 to 4,000. But it really does mean that trade credits can be a bit more proactive in pursuing people that owe them money, which has been essentially impossible for much of 2020. So really the key takeaways from my introductory speech are that you've got to pay attention to cash more so now than ever. You've got to keep your lines of communication with your secured creditors and ATO open. And if you do that, the sense we get is that you'll see cooperation from them and assistance rather than enforcement. And obviously seek professional advice as soon as possible from your accountant or lawyer. There's obviously a whole series of both restructuring and other arrangements that you can enter into to assist you through this period with a view to continue to trade. So with that, I'll get off stage and introduce John McCombe. As I said, he's one of our corporate and commercial lawyers, and he'll speak to you about some of the current climate within that. Thanks, John.
Ladies and gentlemen, thank you for those introductory remarks, Alex. Given that there's a diverse range of business backgrounds and focus in the audience, I've tried to select a couple of aspects of some changes, regulatory changes, basically in and around the COVID issues, which hopefully will be of some relevance to some, or perhaps more than some of you. And it's not property focused as such, so I'll just mention that at the outset. The first observation I was going to alert you to was that a couple of weeks ago, ASIC have formally announced that they're extending the deadlines for the lodgement of financial reports for both listed and unlisted entities by 1 month. That applies to entities that have balance dates between 23 June and 7 July of this year, so that covers the 30 June 2021 balance date entities. The rationale for that is to relieve the pressure on the audit side of things, particularly at the smaller end of the scale, perception being that the larger entities will continue to have their audit needs satisfied in the ordinary way. Obviously, as ASIC has noted, if you're intending to take advantage of the extension of the deadlines, you need to have regard to potential consequences around borrowing covenants and the needs or otherwise of other users of financial reports. Those extensions that I mentioned don't apply for entities that have balance dates from the 8th of January to the 22nd of June, which is a sort of hiatus period between the previous relief, and the rationale for that is premised on there being no apparent resources to meet the audit requirements for those entities. So essentially for public companies, large proprietaries, the extension of 1 month means that the reports have to be lodged within 5 months rather than 4 months from the financial year. Also, ASIC has has adopted a no action position in relation to the holding of annual general meetings. As you may know, public companies who have to have an annual general meeting normally need to do so within 5 months after the end of the financial year. ASIC's no action position allows an additional 2 months for those meetings to be held. It's not a formal legislative change, as it were, but simply a no action position. The reason being that ASIC take the view that they can't amend the statutory timeframe for technical reasons. And in terms of reporting periods for entities after the 7th of July, that's a watching brief on that in terms of the impact of COVID and other things on audit. In terms of general meetings and or otherwise, some of you may be aware there were temporary measures in place to allow companies to hold virtual and hybrid meetings and enabling the electronic execution of documents and electronic communication to shareholders under previous statutory instruments, which actually expired on the 21st of March. They were intended to be extended under the Treasury Laws Amendment 2021 Measures No. 1 Bill, which was before Parliament, but they did not get to consider that before it rose recently. The most contentious part of that, I think, was not so much what I've just mentioned, but the proposed changes to the continuous disclosure regime. So, pending the passage of that bill, ASIC has announced just recently that it would adopt a no action position in relation to the convening and holding of virtual annual general meetings and the giving of notices of meeting. And in simple terms, under that no action regime, ASIC has made it clear that it supports the holdings of meetings using technology, the issue of notices of meeting electronically. There are some conditions. For example, the relief is conditional on voting at meetings on resolutions, including procedural motions, being by way of a poll rather than on show of hands. And by way of background, there's a helpful guide recently published by the AICD, the Governance Institute, Australian Investor Relations Association, and the Law Council of Australia, which was published, I think, in the early part of May. And that has a very comprehensive outline and some tips around holding virtual meetings in particular. One thing to note is that these temporary, the arrangements in relation to quorums under the legislative instruments, attendance electronically worked for quorum purposes, but at the moment they don't. So you need to have regard to your constitution in terms of satisfying the quorum requirements for a meeting. Another matter that received some attention as a consequence of COVID was the electronic execution of documents. Again, there were some statutory instruments in place that allowing that, both at the state and federal Commonwealth level. The Commonwealth instrument, which in particular focused on due execution under Section 127 of the Corporations Act, which applies for most corporates, expired again on the 21st of March. So we've reverted back to the pre-COVID position on that. Sorry, under that relief, broadly speaking, electronic execution and witnessing and what we call split executions were acceptable. That's no longer the case in terms of strict compliance with Section 127, and we have to revert to the pre-COVID practices around execution by corporates to comply with that section. At the Victorian level, there has been some permanent relief around witnessing of documents via audio-visual links and electronic signatures for certain types of transactions, and those permanent changes came into force on the 26th of April. So that's a quick overview there. I thought I might just mention also a case that the judgment was delivered, I think, a week or so ago in New South Wales Supreme Court, Dyker Hotels and Maundy Hotels, in which the New South Wales Supreme Court clarified that the outbreak of COVID and restrictions, business restrictions arising as a consequence of the health orders would not result in a business purchase contract being frustrated where the seller is unable to conduct business in the ordinary course. This matter involved the sale and purchase of the hotel in Piedmont for about $12 million. And the purchaser of the business claimed that the contract was frustrated following the outbreak of COVID and the resulting restrictions, in particular the fact that they could only sell liquor and other goods on a takeaway basis. The purchaser argued that those restrictions modified the business operations and resulted in the seller failing to comply with its obligation, which is common in business sale contracts, to carry on business in the usual and ordinary course. The court found that there was no fundamental commercial difference between the actual and contemplated performance of the contract, which would make it unjust to hold parties to its terms. The court also noted that the requirement to conduct business in the ordinary course does not require a seller to conduct business in a manner contrary to law. So the message of that case, at least, was that COVID will not necessarily relieve parties from performing their contractual obligations. Of course, that's a broad statement. It depends very much on the wording of the contract and the factual circumstances. A couple of other things that I might just very briefly mention to you. One is the proposed introduction of a mandatory director identification number regime. This was announced as part of the Modernising Business Registers program, first announced by the government in last year's 2020 budget. And the ATO is, in conjunction with ASIC and various other regulatory bodies, developing the implementation of that, including the director identification number regime. The purpose of that is to tackle illegal phoenixing, increase director accountability and traceability, and to prevent stopping fictitious people being appointed as directors. They have to be human beings who consent to being directors. So there's some recent, the terms of that were published a couple of weeks ago. It will apply to existing directors, and there'll be a 12-month period for them to obtain their director identification number. And I think from memory, that's likely to, there's a testing program going on at the moment, so that'll kick in probably late this year, and there'll be a 12-month period for existing directors to obtain their director identification number, which they'll keep forever. And lastly, not necessarily more importantly, just wanted to alert you to the fact that for directors who resign after the 18th of February of this year, if you don't lodge notification of your resignation with ASIC within 28 days, your resignation will be treated as having occurred on the day that you make the lodgement. Now you can rectify that if you make a particular application to lodge a form and make an application to ASIC, but only if you do so within 56 days. So there's a change there. And also in the same suite of changes, except where a company's being wound up, directors will also no longer be able to resign if they are the last remaining director on the ASIC records before leaving the company with no directors. So a regulatory change that perhaps you should be aware of. Look, the last thing is not necessarily COVID related, but it's something that's coming up. As from the 1st of July, there's going to be threshold for, under the Australian Consumer Law, one of the consumer is defined to include a person who acquires goods or services that are priced at $40,000 or less, as from the 1st of July, that $40,000 is going to go to increase to $100,000. So just need to be aware of that. Unlikely that it necessarily needs a change of standard terms and conditions, but maybe worth just having a look at particular actually mentions the $40,000 threshold. So look, that's all I thought I'd mention to you in the time available this morning. As I said, a bit of a mixed bag of regulatory changes, that some of which are COVID related. Happy to take any questions later on. Nick, proceed.
Thanks for that, John. I've got a few slides here that I'll go through. So today we're just going to be looking at the property market and obviously the recovery beyond COVID. Risk versus reward and the opportunity that is before us. What I propose to do in the time allocated today, you'll have to appreciate there's only 10 minutes or 15 minutes. It's not going to be a deep dive into the property market, but I'll be covering off on the major sectors of commercial, industrial, retail and residential. Clearly there's some issues relating to hospitality and tourism markets. Unfortunately, we won't have time to cover that, but needless to say, hopefully they're navigating out of that. But without further ado, I'll move on. In terms of taking a bit of a look at where we are in relation to the property market more broadly leading up to COVID, the first slide here, or the first chart, this is really just where we see yields running, where they have been historically. Clearly, there's been a compression of yields leading up until 2020. The red line there is the bond rate. So it's quite interesting, whilst everyone in the market keeps talking about investment yields firming so much leading into COVID, the reality is there's still quite a departure from the risk-free government bond rate. So we have an instance whereby there are super funds that need to park their money into they have a mandate to put money into investment grade product. And whilst these yields have been compressing over time, they're still providing a return that an educated purchaser is looking to do. The other chart that I've got over there looks at Australia in the context of some other countries, and more particularly our net debt to GDP. You can see that Australia, relative to these other countries, is in quite an enviable position relating to our current debt structure. I'll reference one of our Singaporean directors. We had a conference over Zoom during the COVID period. It was quite interesting to hear him observe that we were down on ourselves a bit in terms of the Australian property market, but he really brought it to a head when he said, don't be too worried, because there's a queue of people wanting to invest in Australia and to reside in Australia. So when these borders do open up, there is certainly some pent-up demand looking to invest in Australia. In terms of the commercial office market, now, perhaps we'll start with the chart over the far side. This will come as no surprise to many in relation to occupancy of offices during or pre-COVID and beyond. Pre-COVID, it's easy to observe there that it was just shy of 100% occupancy across the major Australian office markets. Clearly, in October, it got to its worst period there, particularly in Melbourne and Sydney, which were hardest hit in relation to office occupancy. The PCA data now takes us out to January 2021, where there's been a moderate increase in both Sydney and Melbourne, but you can see more substantial increases coming out of the other states. Now, there's obviously some unexpected shifts in workplace structures that have occurred as a consequence of COVID. It's important to understand and appreciate that businesses still value the workplace. You speak to most businesses out there, and they acknowledge that there is value in productivity and collaboration. But they're in a bit of a state of flux at the moment. There's long-term decisions yet to be made, and the workplace environment will need to change to retain talent. Whereby you look at the employee side of it, the employees are enjoying this increased flexibility and choice which comes about as part of the COVID silver lining. some of the data that's been done by or research that's been done by the PCA suggests some statistics about how employers need to shift their thinking. Technology is the big enabler. Having a discussion with John just before this, all our IT skills improved over the COVID period. They just went to show how actually we can run pretty efficiently working remotely. So that is now a real enabler as to working remotely. And clearly the need to adapt. There's a structural change that will happen that wasn't foreshadowed. To what extent that will change and how people occupy offices and then translating into office investment will be something that needs to be considered, which will obviously pan out in the future. In relation to CBD commercial vacancies, perhaps I'll draw your attention to the traffic light coloured numbering. Sydney and Melbourne have had big experiences, there's no surprise, with an increased vacancy of circa 5% for both. Incentives have also jumped up in both the major markets. Incentives meaning the cash contribution or rent-free period that a tenant would require in the market, and that's market-driven. So both of those are blown out, unsurprisingly, relating to the COVID pandemic and trying to release commercial office space. This is a real interesting chart. This is the impact on the sublease market in the Melbourne market. So clearly we've got around this period, June 2020, we're in lockdown, probably was around March 2020. So the increased supply of sublease space in the market is quite astonishing in terms of how much has come back onto the market. You can see the long-term average running through here. So that, for those that don't know the sublease, in terms of those organisations looking to hive off part of their accommodation. So the market is awash at the moment with some increased sublease office space. So what does this mean for office and the office market? Co-working still has its place, the WeWorks of the world, but clearly that changed. These were a bit of a darling of the industry where people collaborated and took out small office spaces, but it's put a real microscope over this format of working when people are staying to work from home. Increased focus on asset adaptation. That's twofold, really. Those as owners, you need to really understand your asset and how it could be applied, changed to the modern day workforce, and also an increased eye on the repositioning of assets. Could that asset one day be a hotel? Could that asset one day be converted to residential? Those are some of the thoughts that are going through potential purchasers' minds. The other two are quite clear. Access to amenities still remains key to attracting staff. And in our view, you're unlikely to see premium grade tenants shifting now. We still see that the top tier firms that really want to have a stranglehold, also a place in the CBD will remain in the CBD. So we don't see that changing. Moving on now to our observations in the retail market. Clearly, there's been some changes to retail spending and its complexities, which obviously influence the ability for a tenant to pay rent, which flows on to the value of a retail property. Soft during COVID, obviously, but recovering. International border closures have impacted part of it with the tourism-based retailers, but it's on the improve with domestic spending increasing. The government stimulus obviously assisted in pushing retail spending through that period, but we're seeing that that's obviously drying up that stimulus. With the limited immigration that's come through the door, we see that there's going to be 2 to 3% out of the retail market for growth over the next 5 years. And we still have this war chest of savings that have come through via some of these government stimulus that will hopefully be assisted in some way or manner in being reinvested in retail spending. So what does this mean for retail property? We're optimistic about the shift in terms of its growth, that it's going to improve. It's coming off a lower base. It was hit harder than a lot of the other asset classes. Supermarket-based assets, i.e. non-discretionary, those a neighbourhood shopping centre, still remain the safe havens. They're the ones that weren't really affected during the COVID period, as you'd expect. But on the flip side, those relying on discretionary spending, such as your sub-regional shopping centres that might have a discount department store and fashion retailers, they are the ones that were hit hardest, and they've been repriced accordingly. We've seen yields push out to 6s and 7% in that asset category. Strip retail still continues to battle. You only need to take a drive down Chapel Street, Swan Street, Burke Road, Campwell. Some of these strips, which were historically bulletproof, have now got a lot of vacancy through them. And what's really interesting in my mind in this sector is that rents were really high and people were buying them, usually mum and dad investors on really tight returns. And throw into the mix also, you have a tenant in there often that you can't recover land tax on because they're under the Retail Leases Act, and limited redevelopment opportunity because there are small parcels of land, and now you're hit by a vacancy. There's not much room for error in strip retail, and there's a few issues there relating to vacancy, increased incentives and lower rents, which are hurting values. Onto the residential outlook now. Now, clearly, this is a big sector and markets within markets, but as a bit of an overview, I'll talk you just through what we're seeing. The key themes for 2021, obviously, low interest rates, less being spent on international holidays, stimulus measures, they're all driving up prices across most major sectors. What's really interesting and to observe is that the absence of foreign buyers, or at least comparatively to previous years, and yet the market has still gone quite strong and improved. Consumer confidence is at its highest level since 2013. People being locked down in 2020 has meant a reassessment of what people are wanting to achieve and where they're wanting to live, and how that drives their prices and where they're wanting to invest their money. I guess the biggest issue that's working against the residential market at the moment is the increased vacancy, particularly for apartments. We're seeing some clear challenges with the absence of foreign students and borders being closed, added on with increased apartment supply, which is making that market quite challenging. I thought I'd just put this chart up to explain to you about the build-to-rent market, which is an interesting dynamic and change within Australia. Whilst that chart could read as though there's a huge amount happening in Melbourne, there is quite a bit, but the dot up the top, 0.4, that's its composition in terms of its overall contribution to residential property within the state. But needless to say, Melbourne is really one of the key areas where build-to-rent is being invested in. We've got quite a bit under development, a bit under construction, and even more in the pipeline coming through. So an interesting change in housing dynamic that will be happening in not only Melbourne, but across the country. Now, the last couple of slides, sorry to bore you with a bit of bad news with some property tax, but there's clearly some changes coming through that most of you have probably read or aware of. Land tax is proposed to increase by 0.25% for taxable holdings between 1.8 to 3 mil, and then by 0.3% for taxable holdings above 3 mil. We were doing some analysis just in the office the other day, and that's for, obviously applies to both local and absentee owners, but the absentee land tax at the moment is quite astonishing when you actually look at the cost that you're incurring annually as an absentee owner. Whether that will continue to deter some international investors, we'll just have to wait to see. Stamp duty, obviously, premium properties in excess of $2 million rather, will increase the stamp duty rate by 1% from 5.5% to 6.5%. That's proposed by the state government. And probably the one that most interest to our organisation, where we have a large town planning contingent map for many of the developers across the country, is this new tax of 50% for windfalls on rezoned land worth more than $500,000. So needless to say, that's every property, you know, if you're talking about a development property, that if you're clever enough to get a rezoning and improve the development capacity of that land, you're going to be slugged 50% for that uplift, which is quite substantial. There are obviously some budgetary issues that the state government are trying to deal with, and today these are the 3 property-related taxes that they're proposing to change and introduce. So that's all I have today. But Alex, if you want to take questions.
Yeah, I was about to say, does anyone have any questions for Nick or any of us?
Sure.
Yes, Nick, you talked a little bit before about the commercial office market in the city. Do you have any comments on the city fringe market? Because you talked about sub-markets and markets within markets, and the city fringe market is a different market. Any comment on that?
Yeah, look, I think it's still facing the same issues, but I think they're quite different in terms of people wanting to move to the burbs or are into the burbs. I don't think they're going to have the same constraints or issues. I think the biggest challenge through COVID was those trying to come into the city and probably a reluctance to come into the city. But generally speaking, if you're talking about smaller operators in the suburbs, it's still probably not as impacted as what the CBD is. But then again, there's still markets within markets. You know, you go to the Cremorne market, for instance, there's a lot of investment there, a lot of tenant demand in the Cremorne market. But that's not without its challenges. It has softened to a degree. So, yeah, it's still, I would suggest, still has its issues, but perhaps not as bad as the CBD.
Do you think it's likely to perhaps be a beneficiary of some of the CBD fallout?
Yeah, potentially, but it just depends how we're going to evolve with our working habits. Whether that means organisations are going to take out a smaller office, whether it be in Geelong, whether it be in Burwood, whether it be in Footscray, or whether they're going to say to their employees, no, continue working from home. There is an element of that decentralisation that some organisations are considering, but I don't think it's going to be a monumental change by any means.
Thank you.
It's a supplementary question to that. I'm involved in fringe CBD office market at the moment, and I see that it's sort of there's sort of markets within markets at the moment. You know, Cremorne is quite different than where I am in Brunswick somewhat.
Yes.
And I'm hoping that with the subtenancy requirements coming into the CBD, that's going to influence their prices that have enjoyed quite a significant increase into the Cremorne area, moving into fringe CBD as well. We're very close to a railway station and trams, etc. So we're really well located. What's your take on that? Do you think there's going to be a significant increase in price elsewhere?
I don't know that it's going to be significant because you still have your competition issues because even in Collingwood, there's a lot of development coming out of the ground in parts of Collingwood and in other areas in the north. So you're not without competition still. I would suggest that the market is still recovering, but to say you're going to have a monumental shift because people are exiting the CBD and coming into the burbs now, similar to that line of questioning, I don't know that that's necessarily going to be a direct correlation, but you may see some improvement.
Just a question from you today about the insolvency rates compared to all construction property. In the second one, we go to about the distress that facing the market.
So is the question, what are the insolvency rates in those industries?
Yeah, are they increasing?
Yeah, so the answer is, I suppose, related to what I said earlier, that many of those businesses have been kept held up because of some of the stimulus packages. There's certainly some distress in those industries, probably more so where there's pressure because of some of the property pricing issues and potentially being overly geared or reliant on finance, which had been difficult to get. So we're not seeing that flow through to actual formal insolvency situations yet, but I know from people who are clients and people who are in the industry that there is certainly some pressure in that regard, and they're probably having those conversations I spoke about with banks and things like that. Not so much that they're in bad bank, but they're being managed and massaged through the situation. So that's a sort of midway answer. That there's certainly pressure, but it's not flowing through to insolvencies as yet, which obviously can have the potential to have a run-on effect to associated industries and businesses.
And to apply that to property, it's the same. We haven't seen an influx of distressed assets in the market or junior possession type scenarios. And I think in the past they've learned to an extent that in terms of protecting asset values, I'm even thinking back into the Centro days when they were struggling. They didn't. Last thing they were going to do was flood the market with sub-regional shopping centres. You know, it's actually a work-through process that was done and seems to be what might be happening here behind closed doors potentially.
And certainly there is some pressure on owners of commercial properties where they're struggling to get tenants in particular markets. And you spoke about markets within markets as well. So, when you've got a difficulty getting a tenant in, you've got increase in land tax, that obviously does increase the pressure on some of those businesses, but it's not across the board. It really is dependent on areas and type of business. Any other questions?
I've got one for John McCombe. Just to test him out. Now, John, you were speaking, and there's two questions actually.
Yeah.
One's a take-out statement that I'm praying you'll agree with, which the other was silly. In terms of some of the asset hold decisions and so forth, no action decisions. What we have with COVID was a whole bunch of measures to say, geez, none of you can go into the office, so we're going to do all this remote stuff, we're going to delay meetings and so forth. And you did refer to it in one of the contexts of one of the things you've said, one of the important messages as I see it is, it's all well and good that ASIC might not do something about it under the Corporations Act, but you've still got your constitutions and you've still got your rules that apply to your company. The fact that ASIC won't get upset with you for not holding your general meeting in time doesn't stop, or for not having a quorum or whatever, doesn't stop a shareholder who's looking to make a point, taking action for the failure to do it as a shareholder. And so there's that importance of actually looking to your own rules and your constitution rather than just the regulators not doing anything about it.
Yeah, that's all. I agree with that 100%.
Okay, so that's good.
I mean, the benefit of the statute, the formal determinations under the Corporations Act was that they effectively, broadly speaking, override whatever the Constitution says, but the softer no action regime doesn't. Ultimately, if a third party or someone challenges the validity of resolutions passed at a meeting, didn't comply with the Constitution in all respects, there's an ability under Section 1322 of the Corporations Act to go to the court and get it sort of blessed. For broadly speaking, get a very sympathetic hearing on that. But obviously, there's cost and expense, and it's my knowledge that having happened. Not saying it hasn't, but it's an issue. Yeah. So right now, still need to have a go at the Constitution.
If you can comply with that, yeah. Second thing was just in relation to the directors' notifications of their own resignations. It's a tiny point, but it's a pretty important one both for advisors and people who are directors. Traditionally, the company had the responsibility for notifying those changes. Yeah. And this is a real push to put it back on the director to take some responsibility themselves. Anything from a practical point of view, a director who's resigning should attend to it.
Well, I mean, there is actually an existing ability for a director to lodge notice of their own resignation if the company doesn't do it on its way for, I think it's 370 or something. I don't think the measures are designed to move the compliance focus away from the company to the director as such. It's just they don't want companies to be left bereft of directors. So, except for, as I said, in the winding up scenario, if you're the last man standing, there are issues.
It obviously does have a significant flow-on effect as well. If your date of resignation is post-dated, you can be held liable for risks that you had no control over. You've effectively resigned from the business, but because of that post-dating, you can be held liable for it. insolvent trading by way of example, or other things, breaches of directors' duties that you weren't actually in the seat for.
Yeah, so I mean, one of the, if under the new regime, if you don't lodge within 28 days, but make an application within 56 days, it has to ask for evidence. And the main piece of evidence is the written resignation, which is an idea I resign with effect from that should help.
Is there value in every director lodging their own notice regardless?
Well, there's certainly, failing that monitoring, so ensuring that they're informed by the company secretary or whoever when it's being lodged. But yeah, they should be mindful of it. Yeah.
And make sure you do lodge it, which is when you take control of yourself and make sure it's done by the company.
Yeah, that's right.
Thank you very much. Any other questions before we finish up? Awesome. Well, thank you very much to John and particularly for Nick for joining us today with the interesting update on the state of the property market. And thanks to all for attending. Stick around for a drink or another ham and cheese.